Of the statutes adopted by the states and upheld by the Supreme Court in 1976, the most prevalent system that's used is a weighing statute, like Florida had and Oklahoma had and California and others, where the jury weighs the aggravating factors against the mitigating factors. And then there's also the Georgia approach, which is once the jury finds an aggravating circumstance, it has complete discretion whether or not to impose the death penalty or not. But Texas took a very different approach, and its death penalty was upheld by the Supreme Court in 1976 in Jurg versus Texas. First of all, Texas defined capital murder at the guilt phase of the trial, that there were 5 different crimes, that if you committed those crimes, they were called capital murder. And if a person was convicted of any one of those, then the case went to the jury for a penalty determination, and the jury was asked 3 questions. Was it deliberate? Would the defendant be a future danger? That is there a probability that the defendant will commit acts of violence that would constitute a continuing threat to society? And third, was it reasonable in response to any provocation by the victim, which usually doesn't apply. Generally, the first and the third didn't apply, and so the case comes down to the jury's determination of future dangerousness. Notice that what the jury's asked here is to find beyond a reasonable doubt that there is a probability that the defendant will. And of course, the question comes, what is a probability? If there's a 20% probability that it will rain tomorrow, as we are sometimes told, is that a probability? If there's a 20% probability that the defendant will commit future acts of violence, does that make the person eligible for the death penalty? Jurors are never really told the answer to that question, but it troubled some members of the Texas Court of Criminal Appeals when the case was there, but ultimately it was upheld by the Supreme Court in Jurg versus Texas. But the court comes back to a couple of questions that weren't answered then. And that's the question of psychiatrists testifying in these cases. Because what we're talking about here is the future, not the past. These are not, all of our other aggravating circumstances look to the defendant had a record of prior assaultive behavior or a prior murder conviction, or sometimes they're descriptive. But this aggravating circumstance is basically a prediction of the future, and the question becomes, can you really do that? And if you can you rely upon a mental health expert, usually a psychiatrist, but possibly a psychologist, to make a prediction of how this person is going to behave in the future? Well, that's a controversial issue, and it came to the Supreme Court in the case of a man named Thomas Barefoot. He was sentenced to death in Texas, and normally only one psychiatrist testified. If you were prosecuted in one part of Texas, Dr. Grigson would testify. Another part, Dr. Holbrook would, but for some reason, they both testified in Thomas Barefoot's case. 2 controversial parts of it. One, they never examined Thomas Barefoot. They just testified that he would be a future danger based on hypothetical questions that were asked by the prosecutor. And then, so 2 controversial things. One, the prediction itself, and second, based upon a hypothetical question without ever having met Thomas Barefoot, given him any tests, talked to him at all. In this particular case, the defense offered no evidence with regard to, or no expert testimony with regard to future dangerousness. This is Dr. James Grigson, traveled all over Texas, testified, would sometimes testify in 2 or 3 cases in the same week. And in Thomas Barefoot's case, which sort of illustrates what this testimony was like, he was asked a hypothetical question which incorporated all the facts of the crime that had been proven at the guilt phase. And then he testified with a reasonable and psychiatric certainty that Barefoot was fairly classical, typical sociopathic personality. Secondly, that he was in the most severe category of pass. That on a scale of 1 to 10, Barefoot was above a 10. Now, the jury in Thomas Barefoot's case didn't know that this was a favorite little technique that Dr. Grigson used whenever he testified, or in many cases where he testified, to say on a scale of 1 to 10 the person was over a 10. But you can imagine the impact that it would have on a jury in hearing that testimony. And then he testified remarkably that there was a 100% an absolute chance that he would commit future acts of violence. This is what gets really controversial. Can any doctor predict that that a person is going to commit these future acts of violence that will make them a continuing threat to society? Well, at the habeas corpus hearing was held later, and both sides put on evidence with regard to this question. The state put on Dr. George Parker. He was a psychologist, and Dr. Coons, who was a psychiatrist, and they testified, first of all, that accurate predictions can be made, that psychiatrists can make predictions, and second, one who has the characteristics summed up in the hypothetical question asked in Thomas Barefoot's case, is a person who would commit future acts of violence. Well, Barefoot puts on some testimony as well. First, he has Dr. Faison, who's a psychiatrist, and he says no doctor should be giving a diagnosis based simply on a hypothetical question. He said, one of my medical students comes to me and he says, here's what, and he tells me 3 or 4 things about the person. I may make a tentative diagnosis, but I'm going to see that patient, examine the patient, talk to the patient before I make a diagnosis. Dr. Dickerson testified that no reliable prediction can ever be made, that it's just simply not possible to predict whether somebody's going to be violent in the future or not. And that in fact, people are wrong 2 times out of 3 when they try to make those predictions. And finally, Dr. Moynihan, who thought when he started working on it that it was not possible to predict future dangerousness, he comes to the conclusion that it may be that in some circumstances a prediction may be possible and may be ethically appropriate, because one of the questions that was raised in the American Psychiatric Association was whether or not it was ethical for psychiatrists to be testifying about this. So the questions presented to the court in the Barefoot case, is it reliable? And the court has said that because death is different, because the death penalty is unlike any other penalty, there's a greater need for reliability in whether or not to impose the death penalty. Secondly, can you have this testimony based just on hypothetical questions without any examination of the defendant? Now, the reason there's no examination of the defendant is the Supreme Court had held in an earlier case that unless the person was given their Miranda warnings and unless the lawyer was notified, these kind of in-person examinations, which Dr. Grigson used to do, were not permissible. Once that happened, that pretty much ended access by the psychiatrist to the defendants. If the defendant were to call his own psychiatrist and have that psychiatrist do an examination, then the state would be entitled to do an examination. But most of the time, there's not going to be an examination. Later, the question will come up whether or not group characteristics. Can you base the future dangerousness on ethnicity or race? But we'll get to that later. Right now, we look at these first 2 questions that the Supreme Court is asked to decide. Let's go back to the testimony in in Thomas Barefoot's case by Dr. Grigson. He was asked about these studies, both doctors were. He was asked about these studies demonstrating that future predictions of future dangerousness are often unreliable. Dr. Grigson said, well, there are a few people that think that. It's a minority group within the profession, and it's certainly not the American Psychiatric Association that believes that. Well, in the Barefoot case, the American Psychiatric Association files a brief to the Supreme Court, and its brief says that the unreliability of these predictions for long-term future dangerousness is clearly established as unreliable within the profession, and that 2 out of 3 predictions are wrong. So the question comes up to the court, are we going to allow this testimony even though it's wrong 2 times out of 3? The Supreme Court says yes, and an opinion by Justice White for the majority sort of says at the very start, looking back to Jurek, this is almost like asking us to reinvent the wheel. It's a little something of an odd statement to make, because what really was at issue here was the reliability of the evidence that was coming in with regard to this. The fact that it is a difficult one, Justice White says, doesn't mean that it can't be made. He said it's made in other contexts, and it is with regard to committing people to mental health institutions. Usually that's based on the expert testimony of a psychiatrist, that the person is a danger to themselves or others. Whether or not someone's released is based upon a prediction of whether, when released, they'll be a danger to themselves or others. Also, with regard to preventive detention, which used to be very rare, but now is more common in criminal cases. But again, this involves a fairly short period of time. Preventive detention is detaining a person pending their trial instead of releasing them on bail. And it's based on a determination that the court thinks the person may be a danger to the community, or it will be a danger to the community, and therefore they're held in jail as opposed to allowed released. Finally, diagnosis as a sociopath based on prior behavior. He says if you can say, looking at what this person has done, that they have acted as a sociopath, then you can say that in the future. He goes on to say basically, and here's where the case, the ultimate holding in the case, let the adversary system sort it out. We'll let the prosecution put on its evidence, and the defense can cross-examine, it can bring out these studies. If it wants to, it can put on its own experts, but the jury often in a case gives more credence to one expert than another. Nothing wrong with that, and so we'll let the juries sort it out. Of course, the question here is, how does the jury sort it out? How do they do that? Does it depend on, if you've got a witness like Dr. Grigson, who, even though what he was saying was not approved by the American Psychiatric Association, but he's very articulate, very charismatic, has this way of testifying that really connected with jurors, and then of course prejudices and about psychiatry and the law and crime and so forth, do those come into play? Well, the close case, Justice Blackmun dissented, joined by Justice Brennan and Marshall, basically saying the court has got to act as a gatekeeper. We can't let evidence that's wrong 2 out of 3 times come before juries. He points out that not a single reputable scientific source confirms or says that future dangerousness is acceptable. They all agree that it's going to be wrong 2 times out of 3. And so he's concerned about the risk that the death penalty will be imposed because the jury will be incapable of separating this myth from reality, and that in fact the predictions of future dangerousness 2 out of 3 times are not even going to be accurate, so the jury is going to be relying upon inaccurate information. Very important case because allowing this testimony in and allowing Dr. Grigson and others to testify, this is one reason why so many people have been sentenced to death in Texas. Once you get to the penalty phase, the jury was asked these 3 questions, yes, yes, yes. If they answer all 3 questions yes, including this future dangerousness one, then the person's sentenced to death. There's not nearly the flexibility in Texas. There wasn't until a later case, which we'll get to. There was very little flexibility for the jury once it found those 3 things. It was deliberate, future danger to society, and that the victim of the crime did not provoke the defendant, and the response was appropriate for the provocation, which, as I said, is seldom going to be an issue in a case. Well, how reliable is this evidence? Judge Garcia, judge on the United States Court of Appeals for the Fifth Circuit, takes a look at it in a concurring opinion in a case called Flores versus Johnson. He looks at another doctor who testifies regularly with regard to future danger, Clay Griffith. He's testified 22 times to the state of Texas, and he's always found future danger every single time. So I guess whether or not you can predict future dangerousness or not, you can certainly predict how Dr. Griffin will testify with regard to future dangerousness. He's always going to say, and again, he testifies based on hypothetical questions. Judge Garza points out that if you look at what the federal courts, the standards set by a case called Daubert versus Merrill-Dow Pharmaceuticals, is a case, not a constitutional case, but a case based on what evidence is admissible in the federal courts. And it set up a 5-part test that judges were to use before allowing expert testimony to come in. He looks at it, no testing of the theories have been done here. That was one of the requirements under Dow. The extent to which there's been peer review. Well, there's been peer review of future dangerousness, but it's all been negative. So that would be a factor for exclusion. The rate of error is greater than 50%. In fact, it's 2 out of 3. Standards of controlling and testing are non-existent. Normally, for evidence to come in, there has to be some way to have controls and standards in terms of how this evidence comes in. And finally, instead of being accepted in the scientific community, which is required for evidence to come in federal courts, it's been uniformly rejected by the scientific community. So why is it still allowed? Well, he points out one other thing that I should mention here. Making a prediction without even meeting the defendant is seen as inherently unreliable, unscientific, and unethical. Dr. Griffin said here that there was no remorse because there was no evidence from which he could deduce remorse. But of course, he never talked to the man. So how would he know if there was any remorse or not? So why doesn't Dr. Griffin's testimony, why isn't it excluded? It's unreliable. He didn't examine the person in person. It's not accepted under any of the 5 factors in the Daubert case. And yet, Daubert applies to the federal courts. It does not apply to Texas. The ultimate decider of what evidence is admissible in Texas courts is the Texas Court of Criminal Appeals and the Texas Supreme Court. But it's not, the Daubert standard has not been adopted in Texas. And the Fifth Circuit Court of Appeals, the court that decided the Flores case, it's bound by the Barefoot case. So if Texas allows this testimony, then it's going to be upheld, and Flores' death sentence is affirmed by the court. Now we come to Victor Saldano's case. In this case, the psychiatrist, Dr. Quijano, testifies that Saldano is a future danger, and part of that's based on the circumstances of the crime and again, we have lack of remorse, testified to by a doctor who never examined him. But what's controversial is he also testifies that there's statistical likelihood based on 24 factors that he will be a future danger. And one of those factors is that Saldano is Hispanic. So he's saying that we know he's more likely to be a future danger because he's Hispanic. The defense lawyer fails to object, so the Texas Court of Criminal Appeals says it's waived. The Texas Attorney General, that time, later Senator John Cornyn, confesses error. In all the cases in which Dr. Quijano has testified, saying we can't allow people to go to death row based upon expert testimony that they're more dangerous because of their ethnicity or their race, and even though the state confesses error, the Texas Court of Criminal Appeals rejects it in the Saldano case. Ultimately, the federal courts grant relief to people who have been sentenced in this way, except for one man, Dwayne Buck. Dwayne Buck was, again, Dr. Quijano testified, and he said that African Americans like Dwayne Buck were statistically more likely than the average person to engage in crime. But the wrinkle in this case is that he was called not by the prosecution to put this evidence on, but by Dwayne Buck's lawyer, by the defense. So the question becomes, are we going to set the case aside anyway or not? The Supreme Court denies review of the case. Justice Alito writes saying that if it hadn't been for the fact that the defense lawyer presented this, we would reverse this case. Justice Sotomayor, joined by Justice Kagan, says Texas admitted error in 2 other cases where the defense lawyer called this doctor and the prosecutor asked about race on cross-examination and later referred to it in closing argument. Finally, what about future dangerousness? Justice Marshall points out that in the case of Wilbert Lee Evans here, sentenced to death in Virginia, which also uses future dangerousness as an aggravating factor. That's the only basis for sentencing him to death. While he's on death row, there's an escape attempt. In fact, it's a successful escape attempt. And while that's going on, 6 inmates involved in that, Evans took decisive steps to calm the riot. He saved several of the hostages. He prevented the rape of a nurse. And over the time that he was in prison in Texas, his behavior was exemplary. And so Justice Marshall says the sole basis for sentencing this man to death, that he was a future danger, is dead wrong. Not only was he not a future danger, he took heroic steps to save lives and prevent sexual assault on this nurse. Nevertheless, Governor Wilder of Virginia did not commute the sentence. Wilbert Lee Evans was executed by the state of Virginia. He said that Justice Marshall's dissent gave him great comfort. He wrote on it, "Bury me with this," and put it in his pocket right before he went into the execution chamber. So future dangerousness continues to be used in some states, a handful, not that many, but certainly in Texas, which of course carries out far more executions than any other state and has a large number of people sentenced to death. Very controversial, but allowed in the courts, and cases like Evans may make us think twice about it.